This former prosecutor, former assistant state attorney Sue Ann Robinson, now works for the Ben Crump Law Firm. She's in Fort Lauderdale, Florida. So this one, Sue Ann, much different than what they're predicting up in Wisconsin, 1 or 2 days. Now we're into week 3. Big part of that is the 3 defendants and their 3 defense teams. It's adding necessary time. Your thoughts on the process overall, where we are so far, and the difficulties of just the situation, small county, high-profile case, 3 defendants.
Yeah, I mean, at this point, they're cooking with gas. You know, we're getting closer. The issue is, you're exactly right. It's a very high-profile case in a small area. It wasn't moved out of the venue, wasn't changed. So these are all people that are very familiar, not just with possibly the defendants and the case, but even with the inner workings, the clerk's office, the sheriff's office, all the players in the town that are involved in the case or have evidence in the case are people who are also in the jury pool. So they're trying to get qualified jurors seated so that the defense and the prosecution have their opportunity to use their strikes. And I think the judge has been, very, I don't know if the term lenient is appropriate, but in terms of qualified jurors, he has allowed people into the qualified jury pool that I think personally may or may not have been appropriate at times, but he's done it on both sides. And I think his goal is to get to that 64 and then allow the attorneys, the defense attorneys to defend and the prosecution to prosecute in terms of deselecting the jurors that they think are going to be unfair. And to be honest with you, it has been a long process, because there are 3 defendants, because there is so much at stake, because it's such a high-profile case. I think that they are giving the time that is appropriate.
One of those defendants is Roddy Bryant, and his attorney is Kevin Goff. And Kevin Goff has been very vocal about some of the issues during this jury selection process. And one of the things he brought up at the end of last week was the fact that he's a little concerned that there's a segment of the population that is underrepresented, possibly, and the way he describes them are white Southern men, and he goes on to call them, like Joe Sixpack or Bubba. Take a listen.
In this case, it would appear that white males born in the South over 40 years of age without a 4-year college degree, sometimes euphemistically known as Bubba or Joe Sixpack, seem to be significantly underrepresented. I can't say underrepresented in the entire panel of jurors because the race information on the master list is obviously not inaccurate. Also, that list is missing crucial information to identifying this group. So there are 2 issues. The one issue is whether that is a cognizable class. If it's not a cognizable class, then that's really the end of the discussion. If it is a cognizable class, then figuring out what the appropriate evidence would be and what the standard would be is much less so. As I understand it, to be a cognizable group for constitutional purposes, there must be some quality or attribute in existence which defines or limits the membership of that group. Second, there must be a cohesiveness of attitudes, ideas, or experiences which serve to distinguish the purported group from the general social milieu. Third, community of interest present in the group may not be represented by other segments of the population. With all due respect, and without meaning to be stereotypical in any way, I do think there's a real question in this case, whether that demographic is underrepresented in this jury pool. And if it is, then we have a problem with it.
Sue Ann, is he describing racist white guys?
Goff is doing way too much. I think he needs to focus more on his client, on the facts of his case, what he's going to say in opening. He has been making arguments that even the court is like, counsel, when you have an actual legal basis for whatever it is you're asking the court or motioning the court, let me know. He's been complaining about people singing outside. He said that he had an issue with people having banners, people having buttons, attorneys that aren't even on the case, their social media. I just think he is scattered in terms of his thought process right now. And I'm really hoping, just for the sake of his client, that he can find the time to sit down and focus. Him arguing that there's an underrepresented group that he's describing as Joe Sixpack. I mean, if the other attorneys on the defense side face when he's making these arguments, says it all. They're just literally sitting there like, what are you saying? What are you doing? Because the issue at this point is for them to find fair and impartial jurors that can look at the facts of this case and apply the law, period. Not him experimenting on a new class of people that are underrepresented in this particular case. He's doing too much, and he needs to focus more on the facts of his case and his client.
Barbara Arnwine is with the Transformative Justice Coalition. She says that this process is getting a little bit too much, saying that they're dragging their feet. Take a listen.
They're dragging their feet. I mean, I think this church question is ridiculous. I don't know why they keep allowing it. And then today he even asked what denomination. I mean, come on. I mean, this is just, there's a lot of irrelevancy going on in this court. And if they would stay on the relevant questions, focus on the ones that make sense from each side, I think we could get to a jury. But right now, this is just dragging. It's dragging. And a lot of it's because of the irrelevant questions. This is frustrating. It's not, I know that they are distressed. And remember, a lot of their distress is coming from the questionnaires. It's, what people said on their questionnaires. And when I say they, the defense, are clearly distressed. But at the same time, they're playing around with irrelevancies. There was another question, if you heard it today, about did you see protesters? How do you feel about all the protesting? Really? I mean, again, it's just, their attention is not on getting to the trying of this case. Their attention is on irrelevancies, distractions, blame anybody you can but your own clients.
Sue Ann, the judge in this case, Judge Walmsley, he is allowing this to play out a certain way. And let's face it, appellate courts focusing on juries and jurors more than really anything else. Isn't it? I mean, yes, it's painful for all of the parties, including those potential jurors, but in the grand scheme of things, taking the time now is important.
Yes, I agree. And I think that the judge is doing the very, very best that he can. Goff at points in the jury selection is very confrontational with jurors, especially with his line of questioning with respect to their religious affiliation. And this jury is very informed on the facts of the case based on what they've seen, but they're also empowered in the process and understand kind of what their purpose is and are being very vocal in responding to questions. And so at times the court has even had to tell Goff to change his tone or pay attention to his tone, because it becomes very confrontational, almost like a cross-examination, with Goff asking questions, the prosecution doing rebuttal questions, and then Goff coming back in individual questioning, and the court having to remind the defense attorney, hey, listen, these are civilians who have come in to do their civic duty. They're not being cross-examined. They're simply being qualified to become prospective jurors, and you can strike them if you have a reason, a race-neutral reason to strike them. But the fact that the court has had to go that far in terms of advising him, watch your tone, these are civilians that are just doing their civic duty, really says a lot about the tension in the process. And this is someone who initially, if you recall, said, hey, just give me the first 12 people, it's fine. So for him to go from that to now be so honed in on slight details, people's religious affiliation, is an interesting change.
Yeah, that's good. I forgot about that. Yeah, right away when this first blew up, he said, let's go, line them up, take the first 12. Big difference in what we're seeing now as we get into week 3. Still ahead, The Supreme Court taking up challenges today to a Texas law that has virtually ended abortions after 6 weeks of pregnancy. It is a big case. The country has their attention on Washington, D.C. We're going to look at what's at stake. We'll listen to the arguments as well live. That's next. The United States Supreme Court will hear oral arguments in about 25 minutes in two cases challenging a restrictive Texas abortion law. One case was filed by abortion providers, that Whole Women's Health versus Jackson. The other by the Justice Department. That's the United States versus Texas. The justices will hear arguments on the construction of the Texas law, whether abortion providers or the Justice Department can mount federal court challenges to that law. Reporter Joe St. George from Newsy takes a deeper look at how this legal battle in Texas could impact the rest of the country.
This is a woman's health clinic in the Rio Grande Valley of Texas. A sign on the building reads, "Abortion is legal. Our clinic is open." But there are mounting questions nationwide about the legality of abortion going forward, not just in Texas, but around the country.
As a reminder, there are two major legal challenges involving abortion in front of the United States Supreme Court. Today, the Supreme Court is hearing a challenge to a new Texas abortion law. On December 1st, the court will hear a challenge to a new Mississippi law. Texas's new law bans abortions after 6 weeks, with only members of the public having the right to sue violators. Mississippi's law bans abortion after 15 weeks, with the government enforcing violations. Both laws challenge the long-standing Supreme Court principle that states can only restrict abortions after the point of viability, which happens around 24 weeks of pregnancy. The big question perplexing the country is the Supreme Court about to set a new abortion standard in the United States. Starting with today's hearing, because it's all a bit confusing, Paul Schiff-Berman, a law professor at George Washington University, helps us understand.
This case is being taken right now essentially on an emergency basis.
Professor Berman says today's Texas case hearing is mainly a procedural one. Texas officials have argued they can't be sued by the Justice Department over this because they aren't stopping abortions. Regular members of the public are. Justices will decide if legal challenges can continue.
It's not clear who can be sued about this law. So if you want to challenge this law, who are you bringing suit against? Which in turn is a different question from whether Roe versus Wade gets overturned.
Professor Berman emphasizes in all likelihood the country will be waiting months to see if the High Court, with its new conservative majority, actually changes what abortion restrictions can be passed in the United States by state legislatures. In McAllen, Texas, I'm Joe St. George.
All right, thanks to George. That makes perfect sense. Well, we need a little bit more drilling down, so let's bring on another expert, constitutional lawyer, Jeff Lewis. He's in Los Angeles for us. So, Jeff, today is not about Roe v. Wade, is it? For people thinking, oh, the Supreme Court is going to take on abortion. That's not really the case. What are they taking on today?
What they're taking on today is the power of the state legislature to insulate a new law, a controversial law, from federal court review. And what's in play is more than just abortion rights, but substitute guns, voting rights, any controversial issue. That's what's in play this morning.
Texas did something very novel. They developed a workaround, basically, right? To say, all right, listen, this is something that we can now we're going to make the citizens the police force. You can be exposed to lawsuits through this workaround. And it's pretty ingenious, is it not? In terms of, here we are. Now the Supreme Court's going to weigh in. What are you listening for here today, and as we listen to these arguments?
I'm going to be listening for questions from the conservative majority as to whether or not this fiction that there's no state involvement is really real. So, for example, clerks and judges have to enforce this law in the sense that they issue summons and they can impose damages on private parties. If the conservative justices are asking questions about state involvement, I would suggest that the court is going to accept